Hey, thank you, Dr. Kosher. If we can go ahead and start with the first slide, please. And hello, everybody. It's my honor to be here. I'm shouting like you can't hear me already. And I see some of your friendly faces, and some of you have chosen to be behind the screen. So for those of you that I can see, I'll just focus on you and talk to you. And I'm looking forward to the next hour as we talk about the Indian Child Welfare Act, what we need to know on active efforts. Okay, the next slide, please. So here's our brief agenda for the next 60 minutes. We're going to start with a background and history. It'll be very brief about ICWA. And as Dr. Kosher said, when you enrolled in this webinar, you probably saw at the very bottom when you scroll down that they do have available, I believe that was video taped as well, one on ICWA where it goes more into detail, more extensive about ICWA and its history. But today we're going to talk about reasonable and active efforts. Primarily, we're going to talk about active efforts, but I think it's really hard for us to talk about active efforts without first talking about what we know best in child welfare practice, which is reasonable efforts. We're going to look at practice transformation considerations. We're going to apply these to the 2016 final rule of practice. You'll know more about what I'm talking about on that as we roll along through the talk. But we'll have these 11 examples that will help guide us into practice with active efforts for American Indian and Alaska Native kids. We'll do a brief closing recap summary, and we're going to have some questions. So I hope that you'll be thinking in terms of some questions that you might have as we conclude the presentation. Okay, next slide, please. All right, so we start with history. So here we have a brief timeline. You can see here that it starts from the 1820s, and then I've got it up through the 1960s through the 1970s. So the Indian Child Welfare Act just didn't mushroom up overnight. And as you can see through these events that I've listed here, there was a lot of history and a lot of water under the bridge before we ended up with this federal law that we have now had in place for 44 years. So what we're looking at are a series of events that led to the passage of the law in 1978. So what we can see is the onset of the breakdown of American Indian families and communities. So if there was a theme, a thread that I would take through every one of these events, it would be the breakdown of American Indian families and communities as dictated by federal policy. And you know, the reason why we have so much federal policy for American Indian and Alaska Natives is this government to government relationship. It's not about race. And I think that sometimes folks don't know this. They think that because, Indians are browns, and so therefore it's a racial thing. So, I'm not brown, but, I'm also a racial minority. Why don't I have these benefits from the government? And the reason why is this goes back to the treaty making all the way through the late 1800s. We had 100 years of treaty making with the tribes and the government, the federal government, that dictated these policies. So you can see with the policies that I've posted here, the policies are not all good, especially when they lead to the breakdown of families and communities. So all of this was initiated by colonization. And so ultimately it was a quest to exterminate indigenous habitants, cultural genocide, if you will, as well as genocide, to gain power and control of this land base and the rich natural resources that colonization brought about. And one of the things that I want to also mention is when we look at the Indian Child Welfare Act, this is not, again, about race, but it's about cultural preservation of a group of people. So just a quick run through. The first event, Manifest Destiny. The second event was the Indian Removal Act. And the Indian Removal Act brought tribes from the south and from the east to what is now known as Oklahoma. At that time, it was Indian territory. So it was forced removals that occurred before Oklahoma even became a state. That's why we have all of these tribes in Oklahoma, thanks to the Indian Removal Act, because when I mentioned rich resources, folks were forced to move from their homelands so that the colonists, as part of Manifest Destiny, could come in and extrapolate those resources and settlements for themselves. The third event that I put down here was a General Allotment Act, and conducive to Oklahoma, this is further dismantling of tribal governments that already were in existence prior to colonization. And so what happened, instead of shared communal property and living, then there were individual land allotments that were distributed and broken up for the families so that we no longer had this type of communal living. And again, this leads to the breakdown of families and communities. And I know that recently, with all of the national attention that's given to the boarding schools, folks are getting, if you didn't know before, folks are getting and gaining more knowledge of how heinous this was, and also the impact that it continues to have upon American Indian and Alaska Native families. And so finally, the sixth event, which brought it up into my time period, I'm giving my age away, the 60s, and then through the 70s, is we had this mass exodus of children who were being removed out of their homes and out of their communities, and they were placed in homes that were non-native, in non-native communities, and there was little to no regard of what their cultural needs were. Okay, can we do the next slide, please? So I put a couple bullet points up here, just in brief. Indian Child Welfare Act is a federal law. It's not a state law, although some states have adopted their own. Oklahoma has our own Indian Child Welfare Act for the state of Oklahoma. And I know that Minnesota has, I think they call it the American Indian Family Preservation Act or something like that, that's similar. But the one we're talking about today is a federal law, and the goal is to protect the best interests of American Indian and Alaska Native kids. So I put a couple of bullet points here regarding that. And the first one is it establishes consistent minimum, and I want to emphasize minimum. These are minimum federal standards. They're not big, lofty, pie in the sky, unattainable, unreachable, we can't do this. It's minimum standards to lead to unbiased, evidence-based practice that's designed to maintain Indian children in the home or improve reunification efforts. ICWA is the letter of the law. It's also the spirit of the law. So when I'm saying the letter of the law, it's the head of the law. You know, it's the head. We have to comply with it. It is a federal law. And so in some ways, when we think about the head, we think about transaction. Okay, so we have to do this right. But it's also the spirit of the law. And anytime we talk about the spirit, we're going outside of the head, but looking more at the heart. And when we look at the heart and we look at practice, we're going to talk about this in a little bit. How do we transform into a new way of not only thinking, but a new way of doing? And so when we're talking about this, it's understanding and knowing why this was created to begin with, that it wasn't just something else that child welfare workers have to do when they already feel bombarded, but there's actually a reason behind this. Now, when we look at this and I give the explanation for it, you know, it's like, okay, yeah, this law sounds like it can make a difference. It can make a difference in Indian kids that, you know, they can stay in the home, they can maintain their cultural connections with their families. Well, let's take a look and see how we've done with it. Can we do the next slide, please? Okay, 44 years ago, 1978 was when ICWA was initiated. And the data that you see here is contemporary data. So in 1978, and the data was loose then, there wasn't a whole lot that we had, but estimates were that 30 to 40% of all Indian kids were being placed out of their home, away from their communities, and some of them to never return back to their culture. So now let's see, this is what's happening today. ICWA outcomes. Indian kids continue to be 4 times more likely to be removed by state child welfare systems than non-native kids, even when their families have similar presenting problems. Second bullet point, Indian kids are placed in state foster care at a rate 14 times higher than the rate in the general population. 13 states continue to have significant overrepresentation of American Indian Alaska kids in their foster care systems. And I want to say that these 13 states primarily are states that have high numbers of American Indian and Alaska Native populations. And then finally, 56% of adopted American Indian, Alaska Native children continue to be adopted outside of their families and communities. So we have a law that has been in place since 1978 that was designed not only by American Indian, Alaska Native people, but allies to purposely reverse this. But we're looking at data that says we're not seeing where it's really made much of a difference. So the question that I want us to consider is, why are the outcomes not coinciding with the intention of the law? Just food for thought. Could it maybe be influenced by the way that we practice child welfare? Just a possibility to consider. Okay, Dr. Kosher, could we have the next slide, please? Okay, so earlier I talked about transactional practice. And so what is transactional practice? You know, when we break it down, it's a transaction, you know, like we go to the bank, we make a deposit, we do a transaction, we deposit it into the bank. So transactional practice is to do things the right way, to do it right. It focuses on the short-term view. It follows standard operating procedures, and transactional practices encourage us to stay inside the box. Now, do you think maybe that transactional practice is how we're mostly trained in child welfare practice? You know, we're trained to fill out the form. We're trained to follow the procedures or the protocols to do it right. We focus on the short range view. And so when I'm talking about the short range view, permanency is a short range view. You know, we're told that the case has to be closed. You either look at reunification or permanency for the child. So then you set up individual service plans. Those service plans should conclude by a certain date where you check the box. Either the parents did it or they didn't do it. And if they don't do it to the satisfaction, then the court, you recommend to the court. And then often what can happen is then we start to initiate the termination of parental rights. And, you know, I can say, and for 11 years, I served as a clinical consultant for child welfare supervisors at 4 different areas across the state of Oklahoma. And I can say that in general, with transactional practice, normally when we do case management and we want to get out of standard operating procedures and we want to actually think outside of the box, this is usually not commended. It's stay within the box, do what you're supposed to do. Here's your training protocol. This is how we do it here. So I'm going to say that when we're talking about transactional practice in this way, actually, we're talking about reasonable efforts. So let's kind of look at what reasonable efforts are. So if we could go to the next slide. And I want to apologize for some of the wordiness of the slides, but because we're kind of doing it, we're covering a lot in a short period of time, it is a bit wordy, but hopefully this will kind of help you to kind of, if you're a see learner instead of just a hear learner, that we can do both at the same time. So reasonable efforts, the definition that I used here is from Child Welfare Information Gateway, because they've done, I think, a pretty good job of just generally summing it up. And in our states, we also have our own reasonable efforts and how we define them within our states. But I think this is a pretty good generalization of what reasonable efforts encompass. So what does it do? It requires the state to exert a reasonable amount of effort. Wow, well, reasonable amount of effort is kind of loose, right? It's kind of like reasonable to who? When you go into courts, they'll say, are you a reasonable person? As a reasonable person, do you agree with this or do you think this was reasonable? All right. But a reasonable amount of effort to provide parents with services, again, that will assist in the preservation or reunification of the family, 12 to 15 months. It's kind of the standard. I don't know if that's the same. This was 21. It could be changing in 22 because sometimes those can be a little bit fluid. Reasonable efforts are efforts that state social service agencies must exert to help families either remain intact, addressing the problems that place the child at risk for harm with a goal to reunify, right? In some sort of permanency, whether if it's not reunification, then it's something else that could put the child into permanency. All right, so here's some examples of referral services that coincide in a case plan for reasonable efforts. And I know that you all know on this call that there's others that you use out of your little toolbox that you refer clients to. So reasonable efforts is an example of transactional practice. Workers create the individual service plan according to the standard operating procedures. They point the client to the referral services as needed and generally leave the rest up to the client to follow through, to receive the services, to follow through all of those goals and objectives that are part of the case plan. Normally there's a date of when they complied and tick off the box, as the English say, they tick the box. We say they check the box. Reasonable efforts outline how to do things right. This is how we do it when we do it right. Reasonable efforts focus on the short range view. I remember a few years ago, one of the sayings in Oklahoma, and I think it was even on one of the forms of doing an intake, it says, let's talk about, saying to the family, let's talk about what we must do, what you must do to get us out of your lives. That's a short range view. It's not about, once the kids come back, are we going to follow up or anything? Let's talk about what you need to do to get us out of your lives. So transactional practice and transformative practice are different. So let's take a look at how that is. If you would go to the next slide, please. All right, so now we have some differences here. Transformative practice is not to do things right, although it could be doing things right, but it's about doing the right thing. I remember a few years ago, there was a saying, we're doing the right thing because it's the right thing to do. Transformative practice focuses on the long range view. Transformative practice is to work outside of the box. I know when we train child welfare workers and we teach these classes at NSU, and we're looking at transformative practice, one of the main things that we try to input into the students is how to be a critical thinker. I think transformative practice requires critical thinking because it's operating outside of standard procedures, but actually getting creative and innovative as to how you can best meet the needs of this family for the purpose of maintaining the child in the home or reunification. Transformative practice moves the needle beyond reasonable expectations. So now we're looking at, so this is more. It's more than just reasonable efforts. It's about going above and beyond what our normal practice is that's considered reasonable. So transformative practice does speak to active efforts. So prior to 2016, active efforts were not defined. They were mentioned in the 1978 Indian Child Welfare Act, but there were no clear definitions or guidelines as to what this meant. So therefore, then what happened? Public agencies were just like, well, I don't really see any difference between active efforts and reasonable efforts. So we'll just keep doing the way we've always done. We'll just do reasonable efforts. We'll call it active efforts and we'll say it's good enough. And the courts, I think, often were doing the same thing, because when you have this type of regulation and then you don't have any guidelines, it leaves folks up to their own understanding. And usually when we do this, we revert back to what we feel comfortable with if we don't understand and say, okay, well, let's just do reasonable efforts. And, you know, we might throw this or that in there a little bit, and then we'll tell the judge that, yes, we did active efforts when we go to the active efforts, when we go to court, and it's good enough. And often what happened was the judges didn't know any different either. This changed 6 years ago. So if we could have the next slide. What happened 6 years ago? 6 years ago, we had something that was called the final rule of 2016. So this is the regulations and guidelines for implementing ICWA. And it, among other things, it actually does address active efforts. It puts a definition to them, it names it, it defines it, it provides examples of what active efforts look like. So you can Google this, look at the final rule for ICWA, regulations and guidelines for implementation. It's like 90 pages long. And it's not only for the workers, but it's also for the courts. So what it did when they put this together in 2016, it had addressed the issue that there was subjectivity that was going on in state removals of Indian kids. It addressed what is safe reunification. So what is safe reunification in one vein for one group could look different for another group. And what I mean by this is, do you remember the saying, it takes a village to raise a child? Previously, when we were looking at children being removed from the home at alarming rates prior to ICWA, some of these kids were being removed because grandma was taking care of them. And so we had a state system that said, these kids need to be with their parents. They don't need to be with grandma. And so they were removed from the home. So what is safe reunification? What does that look like? What are the nuances for that for particular groups of people? So it also addressed the state inconsistencies in ICWA implementation. So we weren't doing a very good job with it. We were all over the place with this federal law. So there was no standard of practice. There was a lot of inconsistency as to what it meant. So as a result, the final rule ensures the proper implementation of ICWA. I mean, it's like 90 pages. Just look for it at your Bible. Whatever you need regarding ICWA, whatever question you have, it's there. It ensures timely notice to the tribes so that there should no longer be this willy-nilly of, Indian kids being in custody and tribes not being informed. Talks about the procedures for notification. And yet again, if you're not familiar with this, I would suggest that you get this, download it, take a look at it, because yet again, it's also for the workers, but it's also for the courts. It ensures consistent minimal standards in child custody proceedings, and it includes binding regulations for the state. So there are certain specific guidelines that this regulations means it's non-negotiable. These are the regs. This is the rule. It's not guidance. These are the regs, but it provides guidelines for that. So The guidelines with the final rule confirm tribal sovereignty. Tribal sovereignty is a political term. It is in regards to the nation-to-nation relationship that I mentioned earlier that federally recognized tribes have with the federal government. It concerns jurisdiction. So when we're talking about jurisdiction, talking about tribal sovereignty, it concerns jurisdiction that the tribes have a right to have child custody in regards of their Indian kids. Now I can see there's some Oklahoma people in here, and we know that this is, it works, different. Sometimes the tribes say, we want this kid, we want primary custody of this child, we'll take care of them, we'll handle it in our courts. Sometimes tribes say, well, we would, because of lack of resources, we would prefer that the state maintain custody, but we want to be involved in what's going on because it is our child. And then sometimes there's this shared relationship. So this is what it confirms: tribal sovereignty over child custody proceedings of Indian kids. So all in all, what these guidelines did is they took the regs in an effort to help state courts and agencies gain insight in how to implement ICWA into practice. Okay, the next slide, please. So what did they say about active efforts? Now they've defined it. So active efforts, I put on here the higher practice standard. You've heard people say, oh, active efforts is the gold standard. Yeah, okay, I'll go with that. And then I've heard people say, I've heard workers say and supervisors, well, we should be doing active efforts for all of our kids. I don't dispute that. But if we're not doing it consistently, according to federal law for American Indian Alaska kids, then I would say probably it's kind of a far reach that we're doing that for everybody at this point. But we should. I think it's a higher standard that we should strive for. So what is it? It's quality efforts that are active, they're affirmative, they're thorough, and they're timely. So now we're getting some teeth into what it is. It's being defined. There are 4 descriptors here of what active efforts are. Active efforts are tailored to the facts and circumstances of the case. And when I put this in there, it's like, yeah, this is in the regulations. This is in the final rule. And I thought, when you look at this, it's like, well, duh, we're all trained that, when we do case management, it's supposed to be tailored to the facts and circumstances of the case. But there's a reason why this was actually put in here. And it could be that sometimes when we develop case plans, they're not actually tailored to the facts and the circumstances of the case. We might kind of throw some other stuff in there just because we think that, they could probably use that too. Active efforts are intended to primarily maintain or reunite an Indian child with their family. So active efforts is characterized by action rather than speculation or contemplation. At a minimum, active efforts requires that the child's family, the child's extended family, and the child's tribe be drawn into the picture, become a part of this. Active efforts also addresses the need to include tribal service providers. Active efforts need to be, to the maximum extent possible, tailored to the cultural values of the child and the family's tribe. So active efforts is also about culture. It's more than just working with the parents. It's about working with the extended family. It's about working with the tribe. It's about working with folks that maybe the family considers to be like kin, but aren't necessarily blood related. So who can we pull into this equation to help support this family? Active efforts, look at this where I've got the little asterisk. It says active is defined as the worker must assist the parent or the Indian custodian through the steps of the plan. Assist them how? Assist them with connecting, assist them with assessing, assist them with developing resources. All right, now this is looking different than reasonable efforts, do you think? It's looking different. It's not about saying, okay, you've got a problem with methamphetamines. So here's 3 substance abuse treatment centers. I'm going to give you their names. Here's the phone number. Here's the contact. Call them up and see if they'll let you in. And good luck, and call me back and let me know what they said. Now it's starting to look different. There's an Oklahoma ICWA case law that actually refers to active efforts as leading a horse to water. So just kind of a little extra tidbit. Believe it or not, some states have passed laws that establish protections for Indian children that are above the minimal standards of ICWA. If this would be the case, then, so if ICWA is the higher standard, if we have states then that have protections that are even higher than ICWA, then the state laws with those protections would prevail over ICWA. Justice William Thorne, who is now retired, but he's a strong proponent for ICWA. He's out of Utah. He said this about active efforts. He said, active efforts means the social worker should treat the child as you would your own child and do whatever it takes. Another judge, Judge April Atterbury, and she's of the Karuk Tribal Court, and she tells social workers, this is what the judge tells the social workers, they should hold the client's hand from start to finish. Now, interestingly, how this is different than reasonable efforts is there is no specific time limits on active efforts. So what is required depends upon the facts of the case. Now, one of the things that I say to my students, this business about, you have 12 to 15 months to get it together. And if you don't, then we're going to make a recommendation that we start initiating termination of your parental rights. To me, that's not even reasonable. Sorry, folks, but and when I look at that, because these families did not get into this mess 12 or 15 months ago, but yet we expect them to turn it all around. And then the leverage is, if you can't do it in this time period, then we will initiate termination of parental rights. So when I said that active efforts have no time limit, then you're seeing here when we're talking about transformative, we're looking at the long range plan and not the short range plan through active efforts. Okay, could we have the next slide, please? All right, so active efforts should be maintained in a manner that to the maximum extent possible, it takes into account the prevailing social and cultural values, conditions, and way of life of the Indian child's tribe. At one time, I was involved with an active efforts hearing. And so my role was that I came and testified actually for the parents, for the mom, in regards to if active efforts were employed in this case, part of this hearing, and if they were, then how were they employed, or if they weren't employed in this case. One of the glaring things that was missing was this first bullet point here. Little to nothing in regard to the case plan that addressed the cultural values, conditions, and way of life for this kid's tribe. I mean, it just, and I reviewed over 500 pages of the case file, and it was just like, it ain't there. Okay, active efforts should be maintained in a manner that utilizes available resources of the Indian child's extended family, their tribe, tribal, and other Indian social service agencies. So I'm going to stop for a minute. This doesn't mean that the states don't have to provide any services. This means that you find out what is available in that tribe, what resources they have, so that you're working collaboratively, you're working together to meet the needs of this family. So sometimes what I've heard in the past is the tribes want to have their nose in it, then let them provide all the resources. That's not what it's about. If the child is in state custody, then the state has the primary responsibility for the tribe. But isn't it better to partner with tribes, especially when you're looking at how scarce resources are anyway for our clients, to find out what they have that's available that may be culturally inclusive and significant to help this family? And again, utilize individual Indian caregiver providers. Now, one of the problems earlier that I mentioned was that the amount of bias that went on in the court system and in the state system. And, you know, when we're looking at Indian caregiver service providers, sometimes we need to check ourselves and check our institution. If they're a Native American caregiver service provider, then just somehow we feel like they're not as good, or they're not as qualified as maybe someone that we have that's on our resource list. You know, maybe to us, maybe we feel like they're less than because it's something that the tribe does and it's not something that the state does. So just kind of something to consider, because I know, and we know that we are all subject to bias in practice, but I know that this does go on. I've heard it and I've seen it. So active efforts in a manner the maximum way possible to use resources through the tribe, to use resources that are culturally inclusive for the families and for the children. Okay, let us go to the next slide, please. Okay, so I like this. The state of California did this, and I like the way they laid it out, because I've seen some scholars say we shouldn't compare, and I don't know if this is even comparing, but it's kind of laying out the differences so you can see this. So reasonable efforts, choosing standard items for the case plan. How does that compare when we lay it beside active efforts? Working with tribal representatives and parents to identify goals for the case plan and resources. I know most states employ family team meetings or family group conferencing, but when we have these folks come to the table, how much power do they really have? Do we go into the room and do we already kind of draft out and sketch out what the case plan is going to look like, and then we just bring them to the table and say, okay, here's what it's going to look like, so go ahead and sign off, then we'll just check the box to say that you showed up and you were here. So there's a difference in transformative practice and transactive practice. So reasonable efforts, you give the parents a list of parenting classes. Active efforts looks a little bit different. You see there's more here. You go over the list with the parents. You try to find a culturally appropriate class. Yes, nowadays tribes do have these. And you assist the parents in signing up for the classes that their schedules allow them to attend. You identify general counseling one time a week in the case plan. Active efforts is more. It's locating culturally appropriate resources for the family or for the kids, taking them to an intake appointment. Sometimes that's kind of unheard of. Yeah, if they can't get there, then they can't get there. So active efforts is, how can we help you to get there? Do you need a ride? Documenting that the child is eligible for tribal enrollment. The other part of it is helping them get that tribal membership if the kids are eligible and they don't have membership yet in the tribe. Locating a standard substance treatment program, locating when it's culturally appropriate, and identify when the child can visit or stay with the parent in the program. Placing a kid in a frequently used non-Indian foster home. Okay, I get it. I know there's not very many foster homes out there. And if you've got somebody that you can trust, that's good, that will take this child, that can be the easier way. But that is not in compliance with ICWA. So with ICWA, you're using placement preferences properly. Now, I want to say this real quick. ICWA defines the 4 placement preferences, okay, by rank. Some of you may not know that there are some tribes who actually have a different placement preference, and they have a right to do that than what the federal law is. So when you're looking at placement preferences outside the home for these children, ask the tribe, do you have a different placement preference than what ICWA, the federal law, is? Because they can do that. And some of them do. But if you don't know to ask and the question's not asked, then that in itself is not necessarily, maybe not knowing the right questions to ask, but just reverting back to what's easier, which is just, let's just put them in a non-Indian foster home and say, we just didn't have any Indian homes for the children to be placed. So I'm going to say this, we can see here that reasonable and active efforts are related. But the distinct difference is active efforts requires us to do more by going above and beyond what is considered reasonable. In this way, as I said before, active efforts are more about action than speculation or contemplation. So the next 5 slides, here's what we're going to do. We're going to look at how we can apply practice, knowledge, and values in a way that can transform the way we do our practice and bring us into not only ICWA compliance, but doing better as far as using ICWA to meet the needs of the families. Okay, so here's a transformative suggestion. We are not over the families, but we're with the families. We're not ruling over them, but we're bringing them in and we're with them. A few years ago in Oklahoma, there was this mantra that was nothing about us without us. And I think this would apply here. Do you see these examples that are listed here? These are part of those 11 examples that I mentioned that are in the final rule regarding active efforts. So let's just take a minute, take a look at those. This falls under not being over the families, but being with them. Okay, you ready to move to the next one? Next slide, please. Suggestion for transformative practice, honoring and creating space for culturally diverse definitions of family and other ways of parenting. So this causes us to stretch and get out of what we think is the right way to parent according to our cultural standards, and actually stepping into the role of, is this really wrong just because it's kind of strange and different to me? So here we have example 5, 7, and 10 that speak to this transformative practice. Culturally appropriate family preservation strategies, that's showing up again in the most natural setting possible for the visitations and trial home visits. The most natural setting possible is not a DHS office. It's not a police department room. And, you know, how about partner with the families and say, hey, is there a place that you all like to go to when you were together that maybe we can meet at? That's someplace that's comfortable. That is someplace that is relevant to you all as a family, because we can do that. And the most natural setting possible is not always McDonald's. And I know sometimes there's meetings that take place in McDonald's, right? Finally, considering alternative ways, this is critical thinking to address the needs of the Indian child's parent. And when appropriate, the family, if the optimum services, with optimum services. Okay, here's another transformative suggestion. The child is the center of the circle and is encircled by nuclear, extended, like-kin family and the tribal community. This is from the work of Dr. D. Bigfoot Cato from OU. She talks about when we look at this, if the child is the center of the circle, which is traditional in American Indian community parenting, then everybody else encircles that child. So if we're working a case where it's just the child and it's just the parents, and then it's the rest of us outsiders who are trying to help, then actually we're deviating away from what is culturally appropriate parenting for American Indian and Alaska Native peoples. So here's a couple more examples. Diligent search for family members. And I want to say this quickly about diligent search. We should not do diligent search just to see if we can find somebody who's suitable to place this kid in the home. Diligent search should be beyond that. So just because grandma is sick and can't take the child in her home, and so therefore we should just dismiss her and no longer involve her in the case, except for just trying to find a placement so we can get the kid placed. We should say, okay, there's grandma. She's concerned. She loves this child. She can't take the child, but let's bring her into the circle because this family needs all the support that they can get. And we can't, as providers, be the begin all and end all for these families. We've got to bring community in. Finally, taking steps to keep the siblings together whenever possible. And that's a part of reasonable efforts too. So there's overlap there. All right, let us look at the next one. Thank you. Tailor the service plan to the facts and circumstances of the case. This involves comprehensive assessment, looking at what our goal is, monitoring progress and participation. Most of us do that. That's a part of doing things right. But here's something that's different with active efforts, and it's providing post-reunification services and monitoring. You know, at what point then can we say, now we can get out of your life? You know, at what point do we have a safety net where it looks like we can get out of their life, but just in case, here's our number. Give us a call if you feel like things are going awry. Let's see how we can continue to support you. That's long-term planning, right? That's long-term planning. Okay, the next one, please. All right, I said this 3 times. Document, document, document. I told you about when I was the ICWA expert at an active efforts hearing. Oh my gosh. You've got to have documentation because you're the eyes and ears of the court. When it's talking about, it has to be in detailed documentation. They're talking about the court record. The judge has to do that. How does the judge know? It's based upon your documentation. It's based upon what you're saying in court. That's how he or she then makes it a matter of the court record. So the 2016 rule, they even set out, look at these bullet points. Here's ways that we want to recommend that state agencies can document this. Name the issues the family is facing that target active efforts. Provide a list of the active efforts that you led the family and worked with the family to obtain, and explain why these active efforts were the ones that you employed in working the case. Include dates, persons, contact, and other details. Provide the results of the active efforts. Were they less than satisfactory? Did you have to go back in and make adjustments? We should, you know, because that case plan shouldn't be just written in stone. It should be a viable living document that we can go back in and say, oops, okay, this has came up, so let's go back in and let's readjust the case plan to make it better to address the issues that the family is facing. And if you haven't already been through this and you're a child welfare practitioner, you will have your day in court in an active efforts hearing. And it is not fun at all, because, you know, there's a possibility that if it's not to the satisfaction, the judge makes the determination, but if it's not to the satisfaction of the court, then I believe that the law says then those children can go back into that home. I think that's what it says. So, you know, not only do things right, but do it because it's the right thing to do. Okay, next slide. Hey, we're about 5 minutes early, so we have some time for questions. Good. So here's the conclusion. Active efforts requires us to think outside of standard child welfare practices. To do this, we must transform our thinking while being mindful of the letter and the spirit of the federal law. It's needed to build, we call this the 3 R's: respectful, responsible, and reciprocal relationships with American Indian and Alaska Native families and communities. And I was a part of a presentation for the Title 40 roundtable discussion a couple of weeks ago in Kentucky. And I did something similar to this. And so they asked for questions from the audience. And a woman said, I have a question. And I said, what's that? And she said, so what do you do when those relationships are broken with the tribes? And I think we know about that. When trust is gone on both sides, she said, what do you do? And, you know, I said, you don't give up, because all relationships, I believe, hold possibilities for healing. And sometimes what it means is sometimes we have to take off our expert hat and sometimes, you know, say, okay, you know, we were wrong. One of the suggestions that I've made for transformative practices is, if you haven't already been out to that tribe, and go visit them, you know, go see them face to face, get on their turf instead of expecting them to always go to the DHS offices. You come here. Do you ever have a family team meeting at the tribal headquarters? Or, you know, someplace that's conducive to culturally appropriate natural settings for the tribe? Does it always have to be in a public place? So developing those relationships take work, and it doesn't happen overnight, especially when trust has been broken and people come in with already, and I know I've seen this, that their attitudes, you know, I'm not saying that, I mean, on both sides. So it's very important to keep in mind why we're doing what we're doing. And that is to keep those children safe, and if any way possible, to maintain them in the home. And if they have to go outside of the home, then to do all we can to reunify, because that's the long-term plan. And it makes a difference, and it especially makes a difference for those children.